Good evening, everyone. On behalf of Morris County Library, we welcome you to tonight's Zoom, Wills, Trusts and Estates, a webinar with Heather Darling, Morris County Surrogate. A few housekeeping notes. This program is being recorded and it will be available at the Surrogate's website next week. Also, please enter your questions into the chat. Questions will be addressed at the end of the presentation. At this point, I will hand you over to Christina Ramirez, Chief of Staff for Morris County Office of the Surrogate.
Thank you, Anne. Good evening, everyone. I am Christina Ramirez, Chief of Staff for the Morris County Surrogates Court. As Anne said, please feel free to type your questions into the chat during the Surrogates program. She will answer as many questions as possible after her presentation. Each question will be read aloud so that all participants will know the question prior to the surrogate's response. Now it is my pleasure to introduce to you Morris County Surrogate Heather Darling. The surrogate was first elected in 2019 and again re-elected in 2024 and is now serving in her second term. Surrogate Darling received her bachelor's degree from New York University in Finance and International Business in 1990 and earned her law degree in 2002 from Seton Hall School of Law. I'll turn it over to the surrogate. Thank you.
Thanks, everyone, for tuning in tonight. I see we've got a really big crowd. I appreciate that. I hope you all get something out of this. I know that we will do our best, as always, to make sure that that happens. So the surrogate, what we handle is guardianship, probate, and adoption for the people of Morris County. On an annual basis, we average about 3,500 probates per year. This past year, we did 155 new guardianships. At any given time, we're monitoring between 3,500 and 5,000 existing guardianships, meaning if a guardianship is placed on an individual upon attaining the age of 18 years, that guardianship may be in place until that individual is in their 60s or 70s. So during that time, we'll be monitoring. We average about 55 adoptions annually. This year, we had 57 completed adoptions, and we oversee a minors fund with $16 million in that account. The surrogate is the judge of the surrogate's court. So like any other court, we're not allowed to give legal advice. And I'll give you guys a reminder of that when we get to the Q&A toward the end of this. We're going to hold the questions until the end. Let me define for you probate. Probate is when somebody is named the executor of the will, but you can't act until you come to our office and you're appointed to handle probate through our office or administration, which I'll get into a little bit later. Guardianship is a situation where you have somebody who's under some sort of incapacity and a guardian is appointed on their behalf. And adoption, believe it or not, adults can also be adopted as long as the adopting adult is at least 10 years older than the other adult. I won't go into the definition of adoption. I think most people know what that is. But our operations also, in addition to what I said, serve to bring fees in which subsidize county operations. This past year, we brought in $732,000, which is the highest that we've ever brought in. Obviously, as the population grows, we see more activity in our office. And as this happens, the statutory fees go up that we collect on an annual basis. The aggregate amount, they haven't gone up per case in many years, but as they go up, our fees go up, and what we bring in and subsidize our operations and county operations goes up. Here, my overarching goal is really to educate the community, to do events like this, to go out and do other speaking events so that people know how to be prepared for the time that they or their family on their behalf will need to utilize our services. More likely than not, that would be to probate a will. And when they're here to probate the will, obviously it's too late to plan. And coming from a small business background, I also strive to provide not just compassionate, but the most effective services as possible to the people of Morris County. We try to be nimble and efficient for the benefit of our clients. Things that we've done since I started here in 2020, We brought in a reduced fee attorney referral service program. My predecessor had the Blue Book, the Citizen's Guide to Wills, Trusts, and Estates. We brought it back with updated information. We also included some things that we spoke with the Morris County Bar Association, the lawyers that routinely do business with our office, to see what they'd like us to add without turning it into an encyclopedia. We have the personal record of. This little white book is great. You put your personal information in there, your accountant, your attorney, your advisor, your marriage records, your divorce records, your military records. It's like a roadmap to your executor. Obviously, you don't leave it on your coffee table. That one goes with your estate planning documents. It's personal, it's private. You want to leave something on your coffee table? We have our surrogates annual report. People want to see transparency from their government. So what does this do? This details our operations. It talks about how many cases we've done of each variety, what our initiatives are on an annual basis, new staff coming, retirements. We've got pictures. We've got other community activities that we've done. It's thinner than an annual report from Exxon, but it's equally good. So these documents are available by coming into our office, but they're also available on our website. And something else that we've done is really update the website. We've made it very user-friendly. We have an AI search ability on there. It's internal. It'll tell you anything that you want to know about our website and what's called our bench book. You can ask it some questions, a lot of questions. They'll give you really great answers. But also on the website, we've got PDFs of those books I just showed you. We've got videos of events like this called Surrogates Sessions on our website, which this is not. This is a library sponsored event. But we also have something called 60 Seconds with the Surrogate, which is exactly that. 60 seconds or less. Here's a little something. Why should I have a will? What if I don't have a will? Et cetera, et cetera. E-filing is something that we brought forth. E-filing enables you to file your probate matter online, so you do not have to come into the surrogates court to file. For people that are more comfortable coming in, we still have our appointments, and we also now on our website have appointment making services. So you can go on our website when you're sitting with your family on Christmas dinner, and you're talking about the aunt who passed away and you never probated the will. You can actually go online on your phone on Christmas and you can avail yourself of that opportunity to make an appointment. So Monday morning, you won't forget again. You'll already have your appointment. Credit card payment is something that wasn't available as an option when I started. It is now. And we've got legislation pending for something called electronic wills, as well as DocuSign on qualifying documents. So that will make fully remote probate an option for those living far and wide, as well as those with mobility issues, which is the same reasons that we brought forth the eProbate platform in the first place. We've also had partnerships with, for example, our most recent partnership is Morris County Veterans Affairs Office. We help veterans or their families to know what services may be available to them, what opportunities may be available to the family members for a veteran, for specifically a grave mark or flag, something like that. We've partnered with the Alzheimer's Association and several others to help bring the best of both offices to you. As the surrogate, I've served as the section chief of the surrogates statewide, the president of the Constitutional Officers Association, which is sheriffs, clerks, and surrogates. I'm currently the surrogates rep to, or alternate rep to, the NJAC, the New Jersey Association of Counties, and also a member of the NJAC Legislative Affairs Committee. What does all that do? That enables me to go out and exchange ideas with others in the state that are elected county officers and bring the best practices that we have to them and them to us, which makes us better serve our citizens statewide. So getting into the meat of the matter, why you guys are here tonight. So why do you make a will? Simply put, because if you make a will, you get to choose who gets your stuff, and you get to choose the executor that gives your stuff to the people that you choose in the manner that you choose. Your executor, I recommend that you name more than one to serve in succession, not at the same time. So maybe you start with a spouse or a sibling, then you go younger for future executors. Generally, probate in our office takes a week, maybe two at the most. But on a simple matter, if we're not busy that day, it can be the same day. To be clear on this, a will cannot be probated until at least 10 days after the death of the person who has passed away. And this is to allow anyone who has standing to file what's called a caveat, which is an objection to probate. If you don't have a will, we have a process called administration, and that operates under the laws of intestacy. So your administrator would first be your spouse, then your kids, then your parents, then your grandparents, then your siblings, then your aunts and uncles, then your nieces and nephews, and so on and so forth. Under the laws of intestacy, if you don't make a will, inheritance would follow that same the family tree in the same way. So people say it goes to the state. It doesn't go to the state. It goes to your relatives. But if you have relatives that you haven't seen in 20 years, maybe under your will, you would have had different wishes. Maybe you would have given your stuff to a favorite charity or something along those lines. What if you don't want to go through probate for one reason or another, or you don't want some of your estate to go through probate? In that case, you have a trust, designated beneficiary policies like annuities, insurance, and also certain payable on death bank accounts are not going to pass through probate. And while I'm on the subject of trusts, trusts are great tools in the event that you have a second marriage and you had kids from the first marriage, because obviously, if you're the glue that holds your kids to your spouse and you pass away and your spouse survives another 10 years, that relationship may be strained, and everything that you worked hard for after your spouse's death may end up going to their kids and never to yours. So if you have a trust, you can have that trust support your spouse during their lifetime and then pour over to your kids upon your spouse's death as the remainder beneficiaries. Also, as I said, there's a 20-day waiting period from the time that the person dies to the time that we're allowed to complete probate. If you own a small business where that business can't go for 10 days or longer without paying bills and meeting other obligations, a trust might be a good vehicle. It's good for Medicare, Medicaid planning, tax planning. And if you have an individual in the family who has special needs and you want to leave them money, leaving it into trust would not take them out of the benefits that somebody worked so long and hard to get for them. Guardianship. Guardianship is when you have a child with special needs that becomes an adult. You want to make sure that you can take care of them if they're of diminished capacity, or an adult who's unable to care for themselves due to possibly dementia, addiction, illness, or some sort of injury. With guardianships, the goal is to empower them. We make it as limited as possible. If proof is required of an incapacity, it requires 2 doctors. Counsel will be appointed for that individual, and also the guardian's fitness to be the guardian of this ward would have to be shown. Typically, choices for that would be a parent, a spouse, a child, a close friend, or an agency if there's no family that's available. Also, powers of attorney are something that you can utilize to avoid a guardianship. The difference being, under a power of attorney, the ward can still act on their own behalf. So if they're making decisions that are not good for them, then perhaps a guardianship is better. If they're not making decisions at all, then the guardianship would be the one, or the power would be the one exclusively executing things on behalf of the individual who gave the power. But in the case of lacking capacity, that individual would not be able to give power. That's an overview of what we do. I don't want to talk all night. I know I said that kind of fast, but I know there's a lot of people on this Zoom, and I know you guys tune in with your questions. So I'm going to open it up to questions with a couple pieces of housekeeping first. My deputy, Christopher Luongo, is here joining us on the Zoom. I'm also going to be asking him to answer some of the questions, just so that you're not listening to me all night. And then please remember that the surrogates court is a court, and we cannot give specific legal advice. We can only give general advice. So we can't answer questions that start with I or me or my. So for example, I inherited, my aunt left me a house, and my mother, and so on. So if we're asked questions in this manner, our moderator will try to reframe them, or we're not going to be able to answer them. So please try to refrain from asking questions in that manner. And Chris, before we go to questions, is there anything that you wanted to say to the audience that I maybe didn't touch on?
Thank you, Heather. The one thing I did want to mention when you talked about our website, I'm not sure if you said this, but you can search probated estates on our website. So if you want to look up whether a will has been probated, you can go to our website and just to type in search probated estates, and there's a prompt that takes you, and then you can look up the estate. Now it will not show the will. But it'll show whether something's been done. And if you want to request a copy of it, you can just make an application to our court. And it's very easy to do. But other than that, I think Heather, you hit it up and ready to go.
Okay, Christina, questions?
Sure do. Someone asked, what is the surrogate's website? And I typed it in so everyone else knows what it is. marssurrogate.com. And there's lots of information there if you need it. Okay, so let's go to the first question. If there is a spouse, a surviving parent, and siblings, and the person died without a will, who is named in the probate?
Is named in the probate, or who is the
Like an
first one?
administrator, I would guess. How do you choose who is the administrator? Would be, I think.
Under the laws of intestacy, the spouse would be the first to have the option to be the administrator. But the question then is, as far as the children and the inheritance, are the children of the two individuals? Are they children outside of that? Because if they're children of the two individuals, the spouse would also inherit everything. If the children are not the children, Chris, do you want to go forward with this one as far as the kids? Because it's interesting to me with the kids and the parents, and I think you tell it very well.
Well, if their kids are if there's a spouse, the spouse would get everything. But if the children are not the children of the decedent, they would split it with the spouse would get the first 50,000 and up to 200,000, and they would split 3/4 with the children. And if there's a spouse and no children and there's a parent alive, they would split it with the parent. The spouse would get the first percentage, and then they would split it with the parent. So there's a whole different permutation, and you can look it up if you want. The statute is NJS 3B 5-3, and it's on Google, and you can look it up, and that'll tell you the exact distribution of an intestate estate.
Okay. If someone wants to create a trust, do you have to have a will first?
No, they're completely separate documents. A trust can be created, oftentimes is created and even funded during the lifetime of the testator, which would also in this case be the individual that is forming the trust. So the testator also can write a will. The will not take effect until the time that the testator passes, but the trust can be a vehicle, an instrument to hold assets of the testator, either in revocable or irrevocable format, until such time as the testator passes away, at which time then the trust will go on potentially to benefit someone else, or it may have been benefiting someone else the entirety of the time during the testator's life. So they're very separate. They're very separate documents. They do very separate things. They hold different assets. Well, the trust holds non-probate assets. Anything that goes into the trust is going to pass outside of probate. But you can also create a testamentary trust, which is something that's created under the will of the testator. Chris, is there anything you want to add to that?
No, you hit it up.
Well, that gets to the next question, which is, what is the difference between a irrevocable and a revocable trust fund?
Okay, the difference between a revocable and an irrevocable is if I sell you my car, right? It's gone. That's irrevocable. Unless you want to return it to me and I want it back, it's gone. But if I give you my car to borrow for the day while your car is at the shop, then that's revocable, right? That's coming back to me at the end of the day. That's the most basic way I can explain it. Revocable means it's still yours. And what the difference is if it's still yours, if you're sued, if you need to go into a long-term care facility, then any creditor, whether it's the facility or the individual suing you, can take that money from you. It can be taken in a marital situation, in the case of a divorce, under a lot of different situations, because revocable means it is still yours. Irrevocable means you've given it away. You no longer have any power over that money. You don't have a power to appoint it. The document tells the testator what it's for, the trust document, but you don't get to tell the trustee, you don't get to tell the trustee what to do with that money outside of what the document that you drafted, i.e., the trust, tells that individual to do. So, for example, if you live in a house that's owned by the trust and you want to sell that house and move somewhere else, technically, if you sell that house, the money goes into the trust, and the trust would have to buy you another house somewhere else, where the trust would have to buy for the trust another house, but you could never take that money back out unless you replaced it with equal property or money, equal value. Chris, you want to add anything to that?
No, I think you're batting 1,000, Heather. So keep it up.
Thanks, Chris.
Okay, in a situation where the spouse is the first or is the executor, and you don't really have someone that you can trust to be the successor of the spouse should they not survive, do you have any recommendations on what you need to put in your will if you don't have someone you can trust as a successor to the original executor?
That's an interesting question. If you don't have a relative, you can name an attorney, but it depends on your age. You don't want to name an attorney who's older, who's going to, not be around when you pass. You can also try a bank, but that's my recommendation, either an attorney, or find a close relative, not, I mean, a neighbor, someone you trust. And it's not a bad idea to name two people as co-executors. Again, if it's a very large estate, I'm sure you can persuade someone to do it. It's tougher when it's a smaller estate, but it's good that you're thinking about that now and planning out, because that it does come up a lot where people name executors and they're usually they're the spouse, and the spouse passes away. So if there's children, that's easy, but when there's not children, it becomes a problem. So it's good that you're thinking about that, and I would recommend an attorney or a bank or a close neighbor.
Okay.
Chris, I have a question. Since you answered that, the second half of that is if it's a sizable estate. You said if it's a sizable estate, you can persuade someone to be the executor. Why?
Just it's cost prohibitive for I know, for example, when we want to have a trust established in New Jersey for someone who's disabled, most banks won't touch it unless it's $1 million. So, and it's the same thing with being an executor of an estate. A lot of times people add, banks, and if there's not enough money, they're just not interested. So that's why appointing attorney helps, or a law firm, that really they're more inclined to take a case like that. So it's really, but it's
the
really,
the bottom line, Chris, your statutory fees. You have to tell them the statutory
oh,
fees. That's
okay.
why, right?
There was the clue. Yes, if to serve as executor, there are fees attached. You pay the executor. It's based on a percentage. It's 5% of the first 200,000, 3.5% from 200,000 to $1 million, and 2% over $1 million. So if it's $1 million estate, it would approximately be $38,000 in executor commissions. So that's what it is. You also get paid on income you receive, and that's 6% of any income. If there's multiple executors, you can also petition. There's another percentage point attached on that. So if you do incredible amount of work, you can also petition the court for additional fees. So it can be lucrative to be an executor or trustee. So that's why I think that's what you're alluding to, Heather, that it can be profitable. But that the reciprocal of that is if it's a smaller estate, it's tough to persuade someone. So, that's why it's not a bad idea to have an individual or multiple individuals be appointed.
Okay. So the next question gets into the types of wills. So the question is the holographic will valid in New Jersey? So you may want to talk about the different kinds of wills.
So various wills, what you want is a self-proving will. If you want to come to our office and have the executor appointed with letters testamentary same day on a slow day that could potentially happen. It might take a couple days otherwise. But if you want them to come in without any issue and be appointed as the executor on that day, they should come in with a self-proving will, which is signed by two witnesses in the presence of the testator and the notary, who then completes an attestation clause as well, indicating that this is a self-proving will. A holographic will is simply evidentiary. It's going to require the individual to go to court and prove that that is in fact the valid will.
But a holographic will is usually in the handwriting of the testator. So unless it's like properly executed, as Heather said, you do have to go to court for that. But if it's properly executed, even if it's holographic, you could still admit it to probate in common form, which means without going to court.
Okay. So the next couple of questions go hand in hand. So what initiates the probate process and how does the probate close?
Okay, so initiating a probate case is making an appointment, coming in with the documents that you have. If you don't have any, then the proofs that this individual passed away, i.e. the death certificate. And it's best if you come in with knowledge, with a list of who the family is. If you're applying to be, for example, an administrator where there's no will, you would like to bring, you should bring the information about the addresses, the names, the next of kin, giving our probate clerks as much information as possible to figure out whether you are the appropriate individual to be the administrator in that particular case. And then in a complex case, let's say that there's a large estate, there's no will, but somebody made a pledge to a charity somewhere along the line. In that case, there's going to be a formal accounting that's going to need to be done at the end. So first you have to get appointed, somebody has to get appointed, and then once that individual's appointed, they go and they administer the estate, they amass the assets, they figure out who the creditors are, they do the math on all of this, and then they do a final accounting in formal form showing that these are all the debits, these are all the credits, there's this much balance, here's how it was to be meted out, and if I meet it out this way, this is the end result. And then once that final accounting is signed off on, the beneficiaries can receive their rightful share once they sign a refunding bond and release, which should be done in every case. Chris, I don't know if you want to go into further details on that.
Yes, in New Jersey, there really that's the scenario Heather just talked about was a case where there's a charity involved. If there's a typical probate where someone dies, they amass gather all the assets, they pay off all the creditors, and then they distribute all the assets to the beneficiaries. There's no formal process to close the estate. There's no like court hearing needed. All you have to do is the beneficiaries have to file what's called release and refunding bonds. and that would end the estate. A release and refunding bond is when the executor gives money to a beneficiary. He gives them a legal form called the release and refunding bond. It's a release that says, I release you from liability. It also says, I agree to refund this money in the event a creditor comes forward that the executor was not aware of. So that form is particularly important. And matter of fact, it's imperative for all executors to be familiar with that form because it protects the executor from any liability. So, but once that form is filed and with our court, and there's a small fee for that, the case is over with. But again, there's sometimes cases are not over because a creditor appears out of nowhere and they can make a claim. Creditors have 6 years to make claims, but most of them don't. Usually it's like within a couple months. But sometimes there's litigation over the executor not doing the job. There's litigation over a will contest. So, but 95% of all probates go smoothly, and there isn't a formal closing process, but you just have to know how to handle it. And the key thing is to pay all the debts, give the money to the beneficiaries, be transparent, and get the release and refunding bond. And you're more than welcome to contact my office. And if you have any other questions about that, I can give you, as like Heather said, I can't give you legal advice, but I can give you general legal principles. So hopefully that answered your question.
Okay.
And Chris, you brought up the point of litigation on an estate against an executor. A lot of times people feel that the executor is not working fast enough, which is interesting because they only have to be diligently pursuing this. It's a requirement, but what does that mean? It's different for every individual. If somebody is physically capable, mentally capable, has all the time in the world and is doing nothing with this, is not working anywhere else, doesn't have small kids in the house to take care of anymore, one would think that you could do it relatively quickly, but it doesn't always happen that way. So we see people getting upset that they're not getting their money fast enough after someone passed away, and that often spurs on litigation as well, or at least the press for litigation.
Right. And I think we have to make the distinction here between probate and the probate process. When Heather talks about probate, that's the actual physical activity of bringing the will and the death certificate down to our office and being appointed the executor. That's relatively easy. It could be done on the 11th day in one hour. Just because it's done in 1 hour doesn't mean the estate is administered in one day. It usually could take anywhere from six months to a year, and 6 months to 2 years, because you have to pay all the creditors, marshal all the creditors, and pay all the taxes. There could be transfer inheritance taxes. As Heather said, if there's a charity, you have to notify the attorney general. So it really behooves people to get legal help with this. It's not necessary. It's not required. You certainly don't need an attorney. Both Heather and I are attorneys. We will be the first people to say you don't need an attorney to probate. But some of these issues do get a little hairy, and the statute says you have to do the probate process expeditiously. It's an SAT word that means fast. So there is a duty to operate quickly, but there's also the reality of modern commerce, and that is things don't always operate quickly. So we do see a lot of litigation on that, trying to remove an executor. But if you're operating in good faith, you're okay, and you're seeking legal counsel in most cases, or that'll definitely move the ball forward.
Okay, next question. Does an heir recipient get step-up cost basis on only a primary residence or on any home owned by the deceased? And who would determine the basis and how?
So while Chris and I could both probably answer that, that's a tax question, and I'm not going to go near it only because I don't want to run afoul of, I am an attorney. I don't want to run afoul of the rules of the court as the surrogate or the rules of the bar as an attorney by giving you tax advice when I'm not a licensed CPA. So I'm going to skip that. Chris, if you want to touch it, knock yourself out.
No,
Otherwise, we'll move right on.
I think the tricky part of that question is that I think the questioner was asking about multiple houses. I know the primary you get the step up basis, but I agree with you. If multiple houses, I do not know the answer. It probably is, but I'm going to give the Heisman on that one as well.
Okay. How does one avoid probate from proceeds from a will or a home sale?
How does one avoid probate from proceeds?
From a will or a home sale? You can't
If
really.
it's, yeah, Chris, does that make sense to you?
No, I think that you can't avoid probate. No, I think that's you can't avoid probate.
No, I mean it sounds to me like somebody, right, wants to inherit without paying the taxes, maybe in paying taxes somewhere along the line, and they want to avoid it. But no, I mean, I'll say this: want to, if you want to put someone else on a deed with rights of survivorship, then in that case, you're going to avoid the proceeds of that sale. And if you want to avoid probate of other financial, you could have financial value. You could have something moved to somebody through an annuity with a designated beneficiary on it. You could have a bank account with, let's say, a POD or something like that. Those things would avoid probate if that's the nature of the question.
Okay. So in the case of a guardianship for a minor child when both parents have passed away, what is the process to get guardianship, and or can a simple handwritten note do?
A simple handwritten note would only be evidentiary in choosing the guardian. Typically, someone would make application through the court, and there would be a relatively substantial process of investigation. There would be investigations of the home, like inspections of the home, making sure that it's a fit environment for the child. Typically, the best placing would be presumably with a relative, so the courts would endeavor to do that. Chris, you want to add anything on
Yeah,
that?
no, it's a tricky question. I mean, because you can, if you can put it in the will that you want the guardian to live with someone, if both spouses are dead, the last spouse could put it in their will that I appoint so and so as guardian, but that doesn't end the process. We would have a right to investigate, including do a criminal background check. And the like. So thankfully this comes up so rarely, and really, and that's the only thing for us. Thankfully, it doesn't happen often.
Okay, so there's more questions about avoiding probate. So I don't know if that means that everybody's afraid to go through probate, but
all right, let me talk about that. So probate in our office can take place in as little as 1 day on a simple matter. It's 10 days after the date of death is the first that you can actually come in and get it done. You can pregame it. You can come in, but you may not get your paperwork. We cannot give it to you until at least 10 days after, so that anyone who wants to bring a challenge has the opportunity to file what's called a caveat and bring a challenge before somebody comes in, becomes the administrator or the executor, and runs off with the proceeds before somebody can challenge if there's questions about this person or the will itself. But probate, the process in our office is not a lengthy or difficult process that people should be looking to avoid. What Chris talked about before when he said 6 months to a year, that's the process of gathering the assets and the debts, and then equating the two out or working the two out and then paying the beneficiaries. That's the lengthy process. no matter how you do it, whether you have these proceeds in trust and you skip a generation for taxes or any other purpose, yes, you're kicking that can down the road, but at some point, the assets are still going to have to get amassed and the creditors are still going to get paid. It's just a matter of how these things are going to take place. Probate isn't this big scary process that people say, I want to avoid probate here in New Jersey. Now, I've heard that in Florida, New York, other places, it takes 9 months, sometimes more than a year. And that's a very different thing. And I'm not saying that I know that for a fact. I'm saying that I've heard that. So people may have had a different experience. But in some states where it takes a lot longer, that might be something that makes more sense to do, or even if other counties are taking longer. But here in Morris County, which presumably you're in Morris County if you're watching through the Morris County Library Zoom, although you may not be, this is where you're going to be probating an estate, or your estate's going to be probated. And this is where these situations are going to come into play that we're talking about tonight. Chris, anything you want to say on that?
You hit it right on the head.
Okay. So in the case of a declining parent and potentially wanting guardianship and siblings cannot get along, do you have any recommendations on how one can proceed because we see this a lot in the surrogates court, even through probate, they can't agree. So do you have any recommendations on how one can move forward if they have a declining parent and they need to, maybe establish a trust or get a guardianship?
Chris, you do a lot of our mediation, so maybe this is a good one for you.
If in the beginning of the process, usually to become guardian, let me just describe the guardianship process. If you have a declining parent and there's no power of attorney, one of the children, presumably, or a relative or a spouse, would make an application. You'd actually file what's called a lawsuit. And attached to that lawsuit would be two medical doctors who make a description of the diagnosis of what the person suffers from and a prognosis whether they're able to govern themselves and manage their own affairs. And once that lawsuit is filed with those two doctors' reports and a certification of assets, usually the children agree. And occasionally, though, children are fighting over their parents. And sometimes I get involved, and sometimes the judge would get involved. But usually it works itself out because you can do co-guardians, you can appoint a third party, you can appoint an attorney. Thankfully, it doesn't happen that often initially, because usually the family, even if they might not agree on everything, they can agree to serve together in the best interest of the incapacitated person. So I can't answer you that there's no way to persuade a family member to behave who's not. But the process generally sorts it out, just the nature of the process. Now, there's one thing I should tell you. When you file the guardianship application, there's a court-appointed attorney appointed, and that attorney is paid out of the estate of the incapacitated person. And that attorney will usually help make a decision. He'll say if there's siblings squabbling over the who's to be the guardian, the attorney will make a recommendation as one, two, or three of them, or any permutation thereof. So the process itself weeds out disagreements. So that's the good news. But occasionally there's a trial on this issue. Very, very rarely. If there's going to be a trial on guardianships, it's usually whether the person's incapacitated. Because usually the court-appointed attorney makes a recommendation, and that usually ends the battle. But it can go to the mat, and that does happen. It doesn't happen that often, thankfully. So most of the time people agree. So hopefully that answered the question.
And I want to add to that sometimes people with bad intentions maybe don't have something and they're looking to maybe skim a little here and there. they typically are not going to be able to get bonded. They're not going to qualify. So that's part of what Chris is talking about. They get weeded out along the way, just based on things we might find. It might be criminal records. It might be financial problems in their own life. There are ways that we're going to find out before that person gets appointed more often than not.
And that's a good point, Heather. I forgot to neglected to say when you do make an application for guardianship, you are fingerprinted and there is a criminal background check. And if there's assets, the judge will require a surety bond, which is a quasi-like insurance policy. And usually if you have to have decent credit to get that. So there again, the process does weed people out.
Okay. Okay, there's a couple more questions on trusts. So it's three parts. Are there tax advantages to a trust? And what is the average cost to create a trust? And is there an annual fee if you have a trust?
Okay, so are there tax advantages? Yes, there can be a lot of tax advantages to a trust. You could have charitable trusts. You could have eh, qualified personal residence trust that pass things over a term of years. Um, you could have multiple different trusts for multiple reasons. In fact, literally, not only are there multiple different trusts, but you as an individual could have multiple different trusts to do multiple different kinds of estate planning. And that's something that you should definitely talk to a seasoned estate planning attorney to have created for you. As far as the cost, I've heard anywhere from a couple thousand to 15,000, 20,000 for these, depending on what it is. And then the fees come in on an annual basis. The fee comes in the sense that if it is a trust that has been created, that has been funded with some form of assets, then your accountant will have to file, that trust will have an EIN number, like a business has an EIN or you have a social security number, and there will be a trust return filed annually by your accountant for that trust. And the tax benefits kind of change depending on what the tax codes are at any given time. So while in let's say as recently as 2002, the estate tax exclusionary amount was $1 million, and now it's $14 million. So it takes a lot more to trigger a tax consequence, but for those to whom it matters, this kind of planning can be very beneficial. Chris, anything you want to add?
No, I think you hit it up.
Okay, so this could be a complicated question. Someone dies and leaves the house in a will to their daughter or to another person. The will was never probated. Then that person dies and leaves the house in a will to the next person. How does this all get mashed out?
The second person would be appointed administrator of the will of the first person, and then they would by operation of that be able to move the first deed from the mother to the daughter, and then from the daughter's executor would move it to the next person. So somebody would have to be appointed as the administrator to probate the estate of the mother, to be the first person to be able to move it. Yes.
Okay.
Chris, anything you want to add?
No, that's fine. Yeah.
Are assets in a savings, annuities, etc., with named beneficiaries distributed outside of a will?
Yes. Outside of probate, outside of the will, outside of probate.
Okay. In a case where there are no children and both spouses pass away, how is an executor notified?
I feel like I know who's asking this question. So how is an executor notified? Look, usually if you're the executor, you know the people well enough to know that they passed away. Presumably, you're either family or you are friends. You have friends in common. Somebody's going to tell you.
We do not
If
notify you because we will not know about it. So that you should put that out there.
so, I go back to, I don't know where I put it. I go back to the white book helps to know where the person's stuff is, but this to notify the executor, I mean, somebody's going to have to find the will and somebody's going to have to notify the executor that they are the named executor under the will. So somebody's going to be going through this person's stuff. Somebody's going to come in. They're going to be looking, whether it's police looking to find somebody to notify. They're not going to tear a person's house apart, but if it's sitting with some documents, they may find it. That's an interesting question, not something that goes through our office at all.
Okay. So quite a few of the questions bring up power of attorney. If I have a power of attorney, what does that give me the right? So you may want to talk about power of attorney for someone who is deceased and where that stands.
Power of attorney is a lifetime document, just like a living will. They extinguish upon death. So a will is a document that does not become effective until a person passes. So power of attorney has no effect once the matter's in our office, once that person passes. Same as a living will. The living will terminates upon the individual's death.
Okay.
I'm
then,
going to throw one other thing in. Power of attorney. People think power of attorney, guardianship. Like I said before, power of attorney and guardianship. A power of attorney is good if a person has capacity, but when a person is of diminished capacity, even in that case, a power of attorney is not necessarily going to get you where guardianship is going to get you. And people think that if they have one, they don't need the other, but that's not necessarily the case. A lot of times you have the power of attorney, but mistakenly you think that you're doing the right thing, but you really should have had the guardianship. All right, Chris, do you want to add to that anything
Unless
since a
there's
couple?
it's what's called a durable power of attorney that comes into operation by reason of a disability. So there's a very specific power of attorney that deals with that issue. Whether, the power of attorney will only come into effect when the person is disabled. So, but you're right, Heather, that if it doesn't say that, the power of attorney, might not be a valid one if it doesn't say that.
okay. So this next question is going to get into something we run into all the time. So if an original will or trust is said to be kept at a lawyer's office and you only have a copy and they are not specifically the overseer of the will, can relatives get the original copy from the attorney? Or
You mean
bring
the original will, not the copy?
the original. They have a copy. They want an original.
Well, the executor should be the one that's getting the original from the attorney if the attorney has it. Now, I'm not necessarily keen on an attorney having it because we were taught in law school not to do that because then there's a presumption you're kind of leading business because now the family's going to go to you as that trusted advisor. So that being the case, or that being said, the executor should be able to get the will from the attorney, and then the family members would be able to get a copy of the will from us, but they do not get a copy from the attorney. The attorney does not owe them that duty.
Right. Some attorneys do hold on to original wills, and that's fine. I mean, I agree with Heather. It's kind of, it's obviously they do it to generate business, but that being said, sometimes they keep it, they're the ones that keep it safe. I mean, there's, the other side to that. But it brings up a more important issue is that we can't probate a copy of a will. We need the original will. There's a theory in the law called presumption of destruction. If you don't have the original will, it's presumed that the testator ripped it up. So you have to have the original will. So that's why it's critical that, you know, whoever gets it, you know, whether it's an attorney or whether it's in a safety deposit box, you got to get the will. Although when someone dies and it's in a safety deposit box, it presents its own set of problems. How do you get that will? But that issue is of critical importance to have the original will in a safe place.
And on that note, don't put it in your safety deposit box. Put it somewhere safe where your executor knows where to find it. You can give it to your executor, but if you put it in your safety deposit box, your executor probably cannot get in there to get it. We do have a way to enable somebody to get in there under the right set of presumptions for the limited purpose of getting the will. But why put somebody through that, and why take that chance?
If your assets are minimal, does one need a will, or would pay upon death be sufficient?
I think you should always have a will. There's always something out there that you're not thinking about, and it doesn't cost that much money to get a will. We even have that reduced fee attorney referral service through the bar if somebody qualifies financially. So, you know, look at the value of what you have, even if it's something as basic as a car and a small bank account. It's still greater value than it probably costs you to make that will. And on the point of the car, something that used to happen a lot was people did have to come in and pay for probate simply because a senior had nothing but their social security check coming in. They were renting or in an assisted living, but they still had that car. The car was 20 years old, was worth next to nothing, and somebody was paying for probate to be able to get rid of that car. And now, when you title a car, you can actually put a beneficiary on the title of the car. So, that being said, if you avail yourself of that, it's one less thing that you do have to worry about. If the person literally has nothing, maybe you don't. But something that we talk about here all the time is it seems like something always comes up. People always say, I never probated it because I didn't think there was anything. If you still have the will, you still know where it is, you can get it done while memories are fresh and the executor's still around. Probably best to just probate the will.
And another reason too to have a will is you can also you can specify the specific funeral arrangements you want, how you want to be buried, whether you want to be cremated. You can really create a roadmap for you know, for your loved ones. I could tell you personally, like I was just with my mother-in-law this weekend. She goes, I don't want to wake. And I was like, boy, that was a surprise. I had no idea. I thought she did. But, you know, if she didn't tell me, we probably would have had it. We'll have one, you know, so it's kind of, that's another reason to have a will.
So Chris and I differ on this because legally he's correct. It's only valid in the will, but people have a living will that goes to the hospital with you. Your estate's not probated till 10 days after the date of your death. Oftentimes nobody finds your will until what's going to be done is already done. So in my opinion, most people go to the hospital at the end. Somehow you end up in the hospital in the morgue. That being the case, if your living will is with you, if that's available, somebody's going to find out before it's too late whether you did or didn't want to be cremated or have a wake or what songs you want to play or as detailed as you want to get. It's not legally binding, but if it's in there, your family is probably going to abide by it, and you're probably more likely to get what you wanted than if somebody found it after the fact.
All right, so we're coming up on an hour, so I'm going to just throw in one or two more questions. Can someone, like a relative, contest a will if they're not named in it?
Chris, you want to go ahead? I did the last one.
Yes, as long as you would have received money under the intestate succession. In other words, um, if you throw out the will and you would be a beneficiary, you can contest the will. But let's say it's a decedent dies and he has 4 kids, and the 4 kids are named as beneficiaries. A cousin can't contest the will because they're not in the intestate succession chain. So they don't have what's called standing. You have to have standing to contest a will. Standing either arises because you're in the intestacy chain, or you have another will where you're a beneficiary. So we scrutinize that pretty carefully, whether you're able to bring that an action either through a caveat or through a lawsuit.
Okay. Okay, if a person owns a house with their spouse in Morris County and one person passes, would the house go to the spouse by default?
It should
Without
go
a
to the
will?
house. If they actually own it together, then the house should go to the spouse.
If it's
Okay.
jointly
You
held.
you wouldn't have to go through probate for that. You could change the deed on that with the death certificate.
All right.
On the second to die, you would have to go through probate.
All right. If a child's not named in a will but listed as a co-owner of a home and land with the decedent having life rights, how is the property distributed legally since the house is included as an asset in the will?
Wait, say that one again. I'm sorry.
If a child is not named in a will but listed as a co-owner of a house and land with the decedent having life rights, how is the property distributed legally since the house is included as an asset in the will?
Well, if the person who's the decedent only has life rights, then their estate terminates, their interest terminates upon their death. So if the child is the co-owner, then the entirety would vest in the child at that point.
I think they mean the kid. The kid is the has life right. I think you mean life estate. I think that's what it is.
Yeah, but who has the life estate? The decedent has the life estate, right?
Well, I took
That's
it as
what
the
they're
kid
saying.
had. I thought took it as the kid has life.
But
It's
you're a
it's
co-owner of the home. So if you're a co-owner, it doesn't matter what the will says, you own
Right,
half the
right. Unless there's a life estate embedded in that deed, it's a tough question to answer because I'm not. I think
right. So if
right. If
someone,
it's
yeah, go ahead. I'm sorry.
so if it's right, if it's a co-owner, and then that the share of the decedent would go to the decedent's beneficiaries. But if the decedent only had the life estate, their interest terminates upon their death, and the other owner, the so-called co-owner, would be the owner at that point because the other individual's estate interest in it terminated.
Okay, we got time for one more question. We're over time. If someone dies in another county in New Jersey, can the will be probated in Morris County, the county in which they live, or the county in which they die?
It's the county where they reside at the time of where they reside at the time of their death. So, for example, if you lived in Montville and you were involved in a car accident in Bergen County and died in the hospital in Bergen County as a result of the car accident or shortly thereafter, you would be considered a resident of Morris County. If you went to a long-term assisted living facility and you were living there full time, you didn't have the house anymore, you weren't going back to the house, then you'd be a resident of Bergen County in that long-term care facility.
Okay. Well, surrogate, do you want to wrap it up?
I just want to thank everybody who participated tonight, not just our viewers, but Chris and Christina and Chris, who there's three Chris's. There's another Chris from my office on here that I don't know if y'all can see, but everybody stayed, everybody pitched in to make this thing successful. Thanks as always to the Morris County Library for putting this event together. They do a great job. I know we had a lot of attendees tonight. I hope that everyone was able to get their questions answered, that had questions. Probably not because we were still getting questions at the end. But the good news is, I think we're going to be doing an in-person one of these again in a few months, in about 6 months or so at the library. So you can catch us there.
and you could also you can email me if you have a specific question as well. I'm at cluongo@co.morris.nj.us.
So yeah, I really appreciate the fact that you guys had these questions, that everybody's so interested in tuning in and getting your ducks in a row, because that's really important. When people come here, it's too late. When your family comes here, it's too late. So you're doing the right thing. And that's all I have to say. Thank you.
Okay. Good night, everyone.
Good night, everyone.
On behalf of Morris County Library, we thank Heather Darling and her staff of the Three Chris's for another informative program. Yes, we are scheduled to host an in-person lunch and learn with the surrogate and her staff in January of next year. Reminder, this evening's session is recorded and it will be available at the surrogate's website next week. Thank you again and have a good evening.
Thank you, Anne.
Thanks, Ann. Take care.